again. Welcome to another episode of Gung Ho. It's September 3rd, 2021, and I am continuing a series of episodes with Jay Goldberg. He's probably the best criminal defense lawyer in the last 100 years, and it's an honor to have him here. And we're talking about the broken criminal justice system, and there's no one that I think knows better about it than Jay, so we'll just start wherever you want to go.
Well, Joe, it's interesting. I don't want to be thought of as an egotist, but the summation in the Bess-Meyerson case was among the 10 best summations in the last 100 years, voted by the American College of Law Professors. They analyzed dozens and dozens and dozens of cross-examinations, or summations rather, and they decided that among the 10 of the last 100 years, summation in the Bess-Meyerson, I don't know if you remember that one.
I remember
was one of the 10 best in the past 100 years. So that's it. More to the point, I've made my life's work in trying to remedy the broken criminal justice system, which causes innocent people to find their way in the grips of a malevolent prosecutor from whom they can't escape. When the prosecutor has made a mistake but won't let go of his belief that a particular defendant is guilty of a crime. Now, a prosecutor has wonderful weapons at his disposal, which the defense lawyer doesn't have. He's got the grand jury for the purposes of investigation. He can compel a witness to give testimony. You, as a defense lawyer, could go to the home of a witness and the witness won't talk to you. But the prosecutor can make the witness talk. The prosecutor can also give offers of lenient treatment to a particular person to get that person to give testimony that will further the cause of his belief that a particular individual committed a crime. Bob Herbert, a columnist for the New York Times, tells a story that there was a trial, and then came the deliberations. And a particular juror held out. A little black lady who believed that the defendant was innocent. She believed in her heart that he had been wrongly accused. And the deliberations went on for a few days, and she was the subject of an attack by the remaining jurors who wanted to get home. And finally, one juror said to her, you know, in 2 days, it's Mother's Day, and your mother's alive, and don't you want to go shopping for your mother? And the woman capitulated and said, let's go, and this way, with my verdict of guilty, we'll be able to go about our business. And the verdict was rendered, and the defendant was executed. It tends to show what the American jury system is all about. It's not composed of scholars. It's composed of people who sometimes will make a judgment, not on the basis of evidence or the obligation of the prosecutor to prove his case beyond a reasonable doubt, but just on the basis of silly things like how the defendant dressed, how the defendant seated at the table interacted with his lawyer. Things that go not to the question of guilt or innocence, not to the question of whether the prosecutor has made out his case, but rather these other factors that interfere with a true and just verdict in a criminal case. And often I tell a story that government proof readily accepted by juries is not justified. Proof in 10% of the cases that have been examined are decided on the basis of forensic proof, fingerprint proof, which we are led to believe is the gold standard, right? When an FBI agent comes in and says, I match the fingerprints of the defendant to the particular weapon, the case is over, because fingerprint evidence is considered, as I said a moment ago, the gold standard. Yet it is not the gold standard. Latent fingerprint analysis is flawed. Bite marks evidence is flawed.
Hair evidence.
And firearm evidence, hair analysis. Anybody going to trial, you must insist that your lawyer, if there's going to be forensic proof, examine a 350-page report issued by the National Science Institute to Congress, which the President Obama commissioned to look into the possible flaws in the justice system by the misuse and readily acceptable proof that thus and so is true when it is not true, when it is subject to careful cross-examination, or even proof that's not acceptable because it doesn't comply with the Daubert standard, which requires a searching inquiry into the expert's experience and gives the judge an opportunity to decide whether the proof is backed up by science. And we take, for example, bite mark evidence. Dentists are called in to give testimony that A, the bite mark supports the fact that the defendant is a guilty one. The proof is often flawed, and it's very important to develop the proof that would lead one to suspect and find that blood spatter evidence, hair analysis, tire track analysis is often wrong. And lawyers don't wage an attack on this kind of proof, but also recognize, as jurors do, that this proof is free from doubt, and that's not so. And countless people are proven to be guilty when they're not guilty, and the result is horrendous. Now, the chief cause of flawed prosecutions is misidentification, that the person has been identified and is the perpetrator of the crime. Well, if I tell you that 50% of the cases that were people exonerated by DNA proof later on. 50% of the cases so set aside because of the existence of DNA evidence is through misidentification. The chief reason for wrongful convictions. Now, when we talk about, the Supreme Court has gone so far as to say the vagaries of the criminal law are such that the annals of criminal law are filled with instances of mistaken eyewitness identification. But mistaken eyewitness identification means executions, 50-year prison sentences, matters of that kind account for people spending their lives in a cell or even being executed because of the flawed science that exists in many criminal cases. I just say to a defendant, if there be one who can hear my voice, if there's proof to be offered of forensic science, that the lawyer examined the 350-page report by the commissioned by Obama into the flawed science and not readily accept fingerprint analysis, bite mark evidence, or the like, because I tell you that the jury is confident about defendant's guilt on the basis of wrongful forensic proof. And misidentification is the other 50%. It is impossible to escape the danger that flows when a witness gets up and says, "That's the man. I'll never forget his face. He committed the crime. He raped me." And these identifications are in error. Not all, but of the ones that are exonerated on the basis of DNA evidence, they are 50% of them from mistaken eyewitness identification.
Okay. There's another factor that results in a lot of innocent people being convicted, and that's misconduct by the police, detectives, and the prosecutors, and the judge going along with it. And
Oh, yes.
I've been up against that from the very beginning.
Yes, Joe.
And I didn't realize how systemic it was. It took me a while to realize how bad it was, but I want to give you an example of how bad it could
I
be.
just want to tell you this, Joe.
Yes.
State judges are often guilty of, this is a word from the cases, lassitude. They go along with the prosecutor. They have their eye on what is politically expedient.
Yes.
They want to be reelected. They want to go to a higher court. And it's usually a state prosecutor
Yes.
who's guilty of these things.
Absolutely.
Not in the federal system, because there people are appointed, AUSAs are appointed, and there is a little experience of wrongful prosecutions in the federal system compared with the state system. And forgive me for interrupting you.
I've experienced, wrongful prosecutions in both the state and federal systems, but this case here, actually a judge, and you know him, Judge Held. I was in his courtroom one day on one of my cases. I had just gone into private practice, and he called me up, and he called the prosecutor up on this murder case. And he just said, there's something, Mr. Giannini, I want you to take over this murder case. Something is not right here. Something is not right here. And he went on to explain that the defendant was sitting in jail for 6 months, and the prosecution had offered him, this is a murder case, had offered him a manslaughter plea. He walked out, and he had to leave the country. And I said, I never heard of such a thing. A murder case, they offer a manslaughter plea, no time, and he only has to go back to Colombia. I said, and the judge said he won't take the plea either. So
Why? Why wouldn't he take the plea? No time.
Innocent.
Right?
So I get on the case, and the judge says, 6 months in jail, you got to get ready. I said to the judge held, I said, I want open file discovery today.
Mm-hmm.
He said, come back at 2 o'clock. I came back at 2 o'clock, and they gave me a file, and it had a lot of what they call DD5s in it, a lot,
Yes.
a lot. And I started going through it, and almost every one of them was prepared by one detective, Joseph Kennedy. But slipped inside there, one other detective had spoken with a DEA agent that was present when the murder occurred. Understand? He was in the back seat, and it was drug related.
Mm-hmm.
And he watched these two guys, these two Colombian guys, argue, and one guy jumped out, the other one after him, and shot him through the back and killed him. The DEA agent gave the information to a detective, and he told him who the murderer was. He knew the murderer. It's like saying, yeah, Joe Giannini was sitting in the passenger side, he pulled out a gun, he killed this guy.
Yeah.
Well, 5 months later, they arrested somebody else. Kennedy arrested somebody else who had no priors, didn't fit the description of the murderer. And I started looking into it, and I came to the conclusion, actually, I found another eyewitness to the murder. I found him, and he described the murder. He didn't fit the description of my client. So I started thinking about it, and I actually think during my investigation, I ran into the murderer. I ran into him. He ran away from me. I went to the DA's office, and I told him this. Your detective, Kennedy, is involved in this murder. Yes. You know what he said to me? We think you're right. We do too. The homicide detective was involved in a series of murders. He was working with Colombian hitmen. They were ripping off drug dealers.
Yes. Yeah.
So I said to them,
a couple of them, right?
Yeah, I said, you have the bullet. It went right through him. See if it matches other homicides, same MO.
Yes.
Well, I said, first of all, you got to walk into that courtroom right now. Bring this guy in and dismiss the case. They did. And I had given the story out to the press, but I told them if they dismiss the case on what I tell them, that's it. You're not going to go with it. And they brought him in, and he was released. And then someone in the Homicide Bureau got back to me and said that weapon was used in 3 other homicides.
Yeah, that was a well-known case that you were on.
And listen, think about it. How could they indict someone, and who rode that case? Bruce Cutler. But he had he rode the case. He went out, he had no recollection of what happened. And that guy, Joseph Kennedy, nothing was done to him. I think he was a psycho killer. He was nuts. Because a few months later, after the case was dismissed, there was an article in the New York Times and said that Joseph Kennedy had killed a guy in the street. He said the guy was running from him and turned on him with a gun. The guy didn't have a gun, a handgun. He had a comb in his hand.
Yeah, I think that's a very important case that you were on. It's a couple of guys who had been bribed by heroin dealers, and they committed crimes. And even behalf of this gang, and you were part of the defense team. Now that was an extraordinary bit of detective work that you did, and it was very important to the community to think that New York City detectives were killers working for heroin dealers in New York.
Yes.
So my hat's off to you for what you accomplished.
Oh, that's only one. I mean, that was horrible. But it was a judge that said there's something wrong here, and he dismissed his private counsel. Said, I want Mr. Giannini on this case. He signed me to the case, and within a month the case was thrown out. Within a month the case was over. But Judge Held was one of those judges, not many, that would, want to do the right thing or do the right thing. There were not many at all. So.
Well, I'm happy to hear that Judge Held was so impressive to you. He was my campaign manager as I ran for a while.
He was a very wealthy guy, right?
Well, he was, he lived on Avenue U, and he ran for office, every office in the city he ran for. And he was my sponsor in my campaign, which lasted just a couple of months because I withdrew for the state senate.
Yeah, I don't think that was for you.
Then I hear now, years later, that he was a strong Supreme Court judge.
I tried a number of cases in front of him. He was always fair to me, which means my client got a fair trial. And we got along. We just got along. Got along very good.
Well, there are many areas of the criminal justice system that people who are otherwise innocent are caught in the grips of the system, and it's very hard for them to escape if they're in the sights, once again, of a prosecutor intent on depriving them of life, liberty, and really the pursuit of happiness.
My experience with state prosecutors is that they're concerned about winning the case.
Yes.
So when a detective brings them a murder case, they really, there were occasions they should say to the detective, this doesn't pass the smell test.
We live by an opinion of Justice Sutherland of the Supreme Court in a case called Berger against the United States, in which he holds that the prosecutor is a representative of the state. He's not interested in winning, but rather seeing that justice is done. He is in reality a minister of justice. And he goes on to say, jurors tend to believe that. And that nonsense is permeated in a number of cases where judges cite the Berger case. And when you attack a prosecutor, you'll find that there's reference to Berger. When you and I know from practicing that winning is everything. If they have to lie, if they have to cheat, if they have to hide evidence, they do that in an effort to win. And for a Supreme Court judge to say that to a prosecutor, winning is not everything, is ridiculous. There's a book, Joe, that came out. I think you gave it to me.
Oh, yeah, Convictions.
By Kehoe. It's Convictions.
Krogan is the name of the U.S. attorney.
Yeah. His name was Keel. And he says his life was not worth enjoying because he spent his time threatening the wife to give evidence that could affect the husband.
Yes.
The
I saw
word
that.
threaten is that he lived by. And that was not the bullshit that is sold to the people who believe that the prosecutor is different than the defense lawyer. No, he's not. He wins at all costs.
When we were talking off the record, off the show, about a guy by the name of Andrew Weissman, and he's got the reputation of being the best flipper ever. In other words, you know what I mean, taking someone and making them into a government witness.
Mm-hmm.
And the way they do it is with threats. And sometimes they threaten to arrest your wife. Sometimes they do arrest your wife.
You're right, Joe. The word with the prosecutor is threaten. They threaten heavier sentences. They overcharge. They'll say to a defendant, if you plead guilty, you'll get X. But if you go to trial, you're going to get 3 times X. And they force people to go to trial, to plead guilty, overcharging.
And they become government witnesses.
Government witnesses. And
we're over again. Damn.
okay.
Damn.